Good morning, Your Honor. This is Ricardo Morales, Spanish interpreter. I have been previously sworn.
Good morning. Thank you, Mr. Interpreter. All right, Mr. Rosales Gomez. Sir, you have been charged with battery domestic violence. I'm going to appoint the public defender to represent you today. I do find probable cause. I'm inclined to set the bond at $2,500. Do we know if Mr. Rosales Gomez lives with the daughter, or is she here?
I do not believe she's here, Your Honor.
They live together?
I am not sure. So state we just request the separate residences and a one-time return, just to ensure that they cannot live together if they do, since she's not here to testify.
Okay. Can I hear from defense? Any on
No, Your
those
Honor.
conditions? Is that fine?
Yes, Your Honor.
Okay. Sir, do you understand? I'm going to order you to have a $2,500 bond. I'm going to order you to maintain a separate residence from your daughter. You can return one time with law enforcement to retrieve any personal belongings, okay? Do you have any questions you'd like to ask your attorney?
No, sir. Still no.
No, sir.
Okay, sir, you have a wonderful day.
Your Honor, state would also request a no contact with the daughter and no weapons, given that it is related to use.
Hold on. I'm going to say no contact. I'm not going to say that no weapons. There are no weapons involved in the incident. So no contact with your daughter, sir. Separate residences. You may go back one time to retrieve your personal belongings, okay? All right, sir, you have a wonderful day.
Your Honor, may the interpreter ask for the defendant's case number?
Case number is 22-4471. Oh, I'm sorry, 2022 MM 4907. All right, Mr. Interpreter, that's our only case with you today. Thank you very much.
Thank you, Your Honor. Have a good day.
Next up, I have Tyveen Ashmead. Are you Mr. Ashmead?
Yes, sir.
Okay. I see this was reset from yesterday due to no probable cause, and I don't see that it's been supplemented.
Yes, Your Honor, I do have a supplement. I have provided one to defense. May I approach?
Yes. Sir, you're charged with attempted burglary of a dwelling and criminal mischief. I'm going to appoint the public defender to represent you. Defense, is there any probable cause argument with this supplement?
No, Your Honor.
Okay. I'm inclined to set bond at $2,500 for the attempted burglary charge,
Yes, Your Honor.
$250 for the criminal mischief charge.
Thank you.
Your Honor, state would ask for a no contact, no return.
Yeah, no contact, no return to the scene. Is that on bond on something? It wasn't written. I didn't get any insight.
Not that they have to prove it yet.
I don't see any information about that. Let's keep him just for a minute. All right, I see he's out on ROR for trespassing. I'm not going to revoke that.
You do. You just appointed a PD. That's why I said call the number.
All right, next up is Mr. McCullen. Sir, you Mr. McCullen? All right, sir, you're charged with trespassing on a property after a warning. I see probable cause was found. Why was the case reset yesterday?
For a plea, Your Honor.
Okay, all right.
And the offer from the state was an adjudication of guilt, credit time served, and no return. State, do you have the address? I don't
It
know.
was the Wawa located at 1200 West Colonial.
And Mr. McCullen would like to accept the state's offer and enter a plea of no contest, Your Honor.
Okay, do you have the plea form?
Yes, Your Honor. For a year. There you go.
Officer. Okay, sir. Yes, counsel?
I don't know. Did she appoint us yesterday? I'm not sure.
Well, if not, I'm appointing you.
Because I didn't sign the plea form, Your Honor.
Okay.
Thank you. There you go.
Thank you, officer. Okay, sir, you are pleading guilty to the charge of trespass, refusing to leave after a warning. Do you understand that?
No contest, yes, sir.
I'm sorry, sir?
Said, no, pleading no contest, right, basically?
You're pleading no contest to the charge, correct?
Yes,
Okay, have you had a chance to discuss that with your attorney as much as you'd like?
yes, sir.
Okay, did you read the plea form in full? I'm sorry, so I need you to speak up.
Yes,
Did you understand it?
yes,
Do you wish to proceed with the plea?
yes.
Okay. Court accepts the plea. Sentence is time served. No return to the scene.
There you go.
You have fines of cost of 273, give you a year to pay, or?
Court costs will be reduced to judgment.
Thank you, Your Honor. I can't breathe.
Next up, we have Sardell Leonard. Are you Mr. Leonard?
Yes.
All right, good morning, Mr. Leonard. I saw he was picked up on a warrant. I don't have wasn't given a copy of the affidavit that was subject of the warrant. Does counsel have a copy?
I do, Your Honor.
Can I
May
have it?
approach?
Yes, please. Thank you, counsel.
And Mr. Learned's case has already been filed as well.
I'm sorry?
It has also already been filed.
All right, sir, you've been charged with the crime of battery and committing domestic violence by strangulation, domestic battery by strangulation. I'm going to appoint the public defender to represent you. I'm inclined to set the bond at $5,000 with no contact and no return to the scene.
Yes,
It's like they don't live together, so there's no need for a one-time return. What's the state's position on the prior bond?
Your Honor, given that he was out on bond and he picked up a new law offense, both being felonies, and that out on bond has been filed, state would request that you revoke at this time. If you're uninclined to revoke, state would ask that you at least revoke and double.
What was the last part of that?
If you're not inclined to revoke and set at none, state would ask that you revoke and double. I believe that grand theft was from a Walmart.
In other words, double the bond on the original charge?
Yes, Your Honor, it was originally 1,000, so state would request 2,000.
Defense?
I would ask that you revoke and double, Your Honor, as opposed to revoking and holding him at no bond. If you want to revoke. It looks like his last offense was in 2018. He has no failure score here. Very limited criminal history.
Your Honor, state's concern is he's also out for the BAT DV, the 20 3574. I'm not sure why it's not listed as a out on bond case. The victim in that case, however, being his mother, Miss Cook.
Defense, is that right? Is he out on another charge right now for the same victim?
Oh, I didn't see that, Your Honor. I did not know.
I didn't either. I don't think that was in my paperwork.
There's no FAD because it happened before the current warrant, so we can't.
Okay,
place
so
a
it's
FAD
not
on it.
out.
I'm sorry, can you repeat that?
We didn't place a FAD, we didn't hold them on it because the offense of the warrant happened before. Well, out on bond happened before the warrant.
So
What am I trying to say?
it occurred prior to this offense? Or- So he technically wasn't out on bond when this
No.
Technically, it wasn't out.
It's in comp proceedings. I'm trying to say.
Oh, it's in
What I'm trying to say.
proceedings.
It's in comp proceedings.
All right, I'm going to set on the grand theft charge a $2,000 bond. All right, are you Samuel Monares? All right, good morning, Mr. Monares. You're charged with battery, domestic violence, and committing domestic battery by strangulation. I'm going to appoint the public defender to represent you. I do find probable cause. I see he's eligible for PTR. I'm inclined to grant the PTR with no contact, separate residences, and no return to the scene. Anything from the state?
No, Your Honor, state's only concern was his lack of community ties. I believe he just moved here approximately, believe it was a week ago or a month ago. So that was the only thing state would bring to your attention, but state has no objection to PTR otherwise.
Okay. Defense?
No objection to PTR, Your Honor.
All right, sir. You're going to be put into the pretrial release program, which they'll give you information on before you leave. Conditions of your release are that you may have no contact with the victim, you must maintain a separate residence, and you may not return to the scene of the alleged crime. If you violate any of the conditions, your pretrial release will be revoked, and you will be back here pending your trial, okay?
What's the question? You guys allowed him to leave the state in pretrial release? To leave the state? Yeah.
You have any questions, sir,
Don't have any,
for your attorney?
do you have any belongings? Okay, so you're fine. Okay. I was asking if he needed a one-time return. He said he doesn't need whatever's there at the house. It was some clothing.
Yeah, I was just wondering if I would.
Yeah, ask your attorney first and follow her advice as to whether or not you should speak.
So there you go.
Okay. Next up is Isaias Satai?
Yes, sir.
Satai, okay. Mr. Satai, you have been charged with battery on a person 65 years of age or older. I'm going to appoint the public defender to represent you. I do see he qualifies for pretrial release. I'm inclined to grant it with a,
There is a victim present, Your Honor.
okay. All right, ma'am.
Yes.
Please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, state, please proceed.
Good morning, ma'am. Can you please state your name for the record?
My name is Xiomara Morales. I'm his
And-
grandson. My grandson.
Okay. Are you afraid of him?
No, it's not. I don't know how he's involved in this because if you see me, he don't hit me. He don't do nothing to me. We just argue and that's it.
Do you believe drugs or alcohol were involved in this incident?
I don't think so.
And do you want to have contact with him while this case is pending?
Excuse me?
Do you want to have contact with him while this case is pending?
Yes. Why not? Yes. He's my grandson.
Are you okay with him returning to the home?
Yes. Yes. Yes.
And he qualifies for a program called pretrial release,
Oh, yes.
meaning he can get out of jail without paying any money, but he would be supervised just to make sure all the conditions that the judge is about to set, he follows.
Yes.
Does that sound okay to you?
Yes. Yes.
State has no further questions, Your Honor, and no objection to PTR.
Defense?
No questions, and we would ask for pretrial release, Your Honor.
Okay. I'm going to grant pretrial release, given the victim's testimony. I'm not going to set any conditions unless the state has any additional suggestions.
Your Honor, state would just ask for a no hostile.
Yeah. No hostile contact. Sir, no hostile contact means no hostility of any kind. It means no crass words. It means you can't even raise your voice. If you violate this condition, you'll be in violation of your pretrial release, and you will be back in jail pending your trial. Do you understand? Yes, sir. Okay. Pretrial release, no hostile contact.
That's it.
Have a nice day, sir. All right, Michael Ainsworth. Okay. Good morning, Mr. Ainsworth. You've been charged with violation of a domestic injunction and a failure to appear. I'm going to appoint the public defender to represent you. I'm inclined to set a bond of $5,000 on the violation of domestic injunction with a condition of no contact. I'm inclined to issue no bond on the failure to appear. Anything from the state?
No, Your Honor.
Anything from defense?
No, Your Honor.
Okay. Sir, your bond is set for the violation of domestic injunction charge at $5,000 with the condition of no contact to the victim. On the charge of failure defendant to appear, I'm not granting you a bond. Have a nice day. Do you have any questions for your attorney? Yes. Yes. DUI. Yeah. Okay, Antoinette Bacon,
Yes.
you have been charged with battery domestic violence. I'm going to appoint the public defender to represent you. I don't find probable cause in this case. State officer says in the affidavit he does not know who the initial aggressor was. Without any evidence as to the initial aggressor, I don't find probable cause on the charge. Anything the state would like to argue?
Your Honor, state would just argue for a battery. There just has to be an unwanted touching, and arguably there was.
If she's not the primary aggressor, it's self-defense, right?
That would be a motion for a later time when it goes.
But not when he says right in here, I have no information that she was the primary aggressor. Without an allegation in the affidavit that she was the initial aggressor, there's no probable cause for the crime.
Your Honor, state would ask for a 24-hour reset to get additional information from the officer.
I have a minor child at home.
Defense?
Your Honor, if you are inclined to grant the state 24 hours, I would just ask that you at least set a low monetary bond so that she's given the opportunity to bond out in the alternative.
The officer states right in there he was unable to determine the primary aggressor. It's not a lack of information. He affirmatively states it. I'm going to find no probable cause. I'm not going to grant the 24 hours. Ma'am, I'm finding no probable cause for your arrest. You'll be free to go.
Thank you. Thank you very much.
Yes. Yes, ma'am, your criminal case was still pending, and the state may still proceed charges, but I'm finding they do not have probable cause to hold you at this time. You'll be released today, okay? You may ask any questions of your attorney, and if she allows you to speak, you may speak to me. But speak to your attorney first.
So call the attorney, see if they can.
So,
Okay, David Paul Murphy?
Yes, sir.
Are you Mr. Murphy? Good morning, sir. You have been charged with battery domestic violence. I'm going to appoint the public defender as your attorney to represent you today.
Yes, sir.
I see he qualifies for pretrial release. I'm inclined to grant the pretrial release on the condition, do we have a victim here?
No, Your Honor.
On the condition of no contact with the victim, separate residences, and no possession of any firearms or weapons. Anything from the state?
No, Your Honor.
Anything from defense? Take your time, sir, if you need to speak with your attorney.
Just a second. We would ask for pretrial release, Your Honor.
Yes, that's what I said. Pretrial release on the conditions of no contact, separate residences, and no possession of firearms or weapons.
Yes, yes, sir.
Okay, do you need sir, hold on, sir. Does your client need a one-time return, counsel?
Alternate address provided.
Yes.
Yes,
Yes.
Your Honor.
Okay, so it's going to be pretrial release, no contact with the victim, separate residences. Sir, you may return to the residence one time with law enforcement to retrieve your belongings. Other than that, no return to the residence. And you must surrender any firearms or weapons within 24 hours.
Yes, sir.
You understand?
Yes, sir.
Okay. Have a nice day, sir. Okay, Frank Person?
Yes, sir.
Okay. Good morning, sir.
Good morning.
Sir, you've been charged with battery domestic violence. I'm going to appoint the public defender to serve as your attorney today. I do find probable cause. I'm inclined to set the bond at $2,500 with the condition of no contact. Anything from the state?
No, Your Honor.
Anything from defense?
No, Your Honor.
Okay. Sir, I do find probable cause for your arrest. I'm setting your bond at $2,500. One of the conditions of your release is that you may have no contact whatsoever with the alleged victim. That means no phone calls, no text messages, and definitely no in-person contact. If you violate the conditions of your release, your bond may be revoked and you will be in jail pending your trial. Do you understand?
Yes, sir.
Okay, do you have any questions for your attorney before you go?
That's yours? I mean,
Yeah, they're gonna give you.
All right. Mario Robinson?
Yes, yes, sir.
Good morning, sir.
Morning.
You've been charged with 4 counts of battery domestic violence. I'm going to appoint the public defender to serve as your attorney today. Does the state have a request as to the bond?
Your Honor, state would request to talk to the victim first.
Okay.
Hi.
Ma'am, would you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Okay, and what is your name?
Janita Jones.
Okay, can you spell that for us?
Shenita.
All
Last
right,
name
state-
Jones. Jones.
Thank you, ma'am. State, please proceed.
Good morning, Ms. Jones. Can you please state your relationship to Mr. Robinson?
He's my ex-boyfriend.
Are you afraid of him?
Yes,
Has anything like this ever happened before?
yes.
Approximately how long ago was the last time other than this time?
March 2022.
Do you believe drugs or alcohol were involved?
Yes,
Which of the two?
marijuana drug, yeah.
And do you want to have contact with him while this case is
No.
pending? And is there anything else you'd like to tell the court?
I have an injunction on him. It was served on him last week. We have a hearing that's coming up. I just don't want no contact with him via social media, no, because, I mean, what I went through with this guy is tremendous. I did, give him a second chance. The first time he put his hands on me, I dropped the charges. That was the worst thing I could have did because it got worse. And he embarrassed me. He came to my job and he constantly, hit me. And I just don't want to have nothing to do with him. That's why I'm here today. And I'm going to pursue charges to the best of my ability.
Thank you, ma'am. That's all I have.
Defense, any questions? No questions. Okay. What's the state's request for a bond?
Your Honor, it does appear Mr. Robinson does have previous BAT DV arrests. So given that it's 4 counts, state's requesting that you not treat them as subsidiaries. But since they're misdemeanor BAT DVs, State's asking for 1,000 on each count.
Defense?
No objection, Your Honor.
Bond will be set at $1,000 on each of the 4 counts, $4,000 total, with the conditions of no contact with the victim whatsoever, maintaining of separate residences, and no consumption of drugs or alcohol, illegal drugs or alcohol. Ma'am, were the two of you living together?
Yes.
Counsel, does your client need a one-time return?
No, I don't stay there no more. I moved out.
Oh, okay. Are the belongings still there? Is the,
No, I don't have anything there. That's his residence, so he's free to go back to that
Okay.
residence.
all right.
Yes, sir.
Ma'am, thank you for being here.
Thank
for your
you.
testimony. All right, sounds like you can go back to the residence. She's not there. Sir, I'm setting your bond at $1,000 on each of the 4 counts. The conditions of your release are that you may not consume any drugs or alcohol, that means at all, and that you may have no contact whatsoever with the alleged victim. That means no contact, that means no Facebook messages, no Instagram messages, no phone calls, and definitely no in-person contact. If you contact her in any way of any kind, even just to say good morning, you'll be in violation of your conditions of release, and your bond may be revoked, and you will stay in jail pending your trial. Do you understand the conditions of your release?
Yes, Your Honor.
Do you have any questions for your attorney before you go?
No, that's all.
Okay, sir, you have a nice day.
You too, man.
You're welcome. No, you're fine.
Good morning, Your Honor. This is Laura Royo, State Certified Interpreter and previously sworn.
Thank you, Madam Interpreter. Okay, Mr. Montellano?
Sí.
Okay. Sir, you're charged with failure to appear and a violation of your conditions of pretrial release. I'm going to appoint the public defender to serve as your attorney. Do you understand?
Entendido.
Understood.
Okay. This is case number 2019 CT 9220. I'm going to no bond this one. Anything from either side?
No, Your Honor.
Okay, sir. For your charge of failure to appear and violations of the conditions of your release, I'm issuing no bond. You'll be held. Do you have any questions for your attorney before you go?
Sí.
Yes.
Es que yo cumplí
Well,
con todo eso.
hold on. Speak privately with your,
She speaks Spanish. I don't speak Spanish, Your Honor.
okay, is there a way I mean, I guess I don't,
No hablo mucho inglés.
no, I know,
You
but
don't
is there a
speak
way
much English.
is there a way that I cannot hear what the interpreter says? Because he has a right to speak privately with his attorney.
No, Your Honor, usually.
Unfortunately, Your Honor, they don't have a second headset at the jail. There used to be, but no longer is there one.
Okay, can you, Madam Interpreter, just tell him that he has a right to speak privately? Unfortunately, our interpretation services don't allow it right now. But I can find somebody in this jail who speaks Spanish if we need to, if he would like to
We
speak
have.
privately.
Sí.
Yes, please.
Yes.
Can you get Ortega?
Can we flag down somebody who speaks Spanish?
We have one.
Yeah. Thank you, Madam Interpreter. Was this the only interpreter case? Okay, just hold tight, Madam Interpreter.
Yes, Your Honor.
Yeah, he has a constitutional right to speak privately. I want to respect it.
Sí, está bien.
Yes, very well.
Your Honor, is it okay if we just stand right outside the door? Because I don't want it to be recorded.
Yes, I think that's fine. I'm sure there's an officer will be with an eyesight. Can you guys just let them speak outside so that they can speak privately? Obviously, somebody, keep an eye on them.
Yep. He's gonna be right. This is yours.
Take your time.
You gotta bring somebody in? Oh.
We're going to go off the record while they're outside. Next up, we have Dorinda Kelly. And Madam Interpreter, that's the last interpreter case, right? Yes. Madam Interpreter, thank you for your work.
You're welcome.
Oh, they're gone, okay.
Are you Dorinda Kelly? Yes, I am. Good morning, Miss Kelly. You're charged with resisting an officer without violence and being in the park after hours. I'm going to appoint the public defender to serve as your attorney.
Your Honor, I was going to ask for an ROR in this case. She has been found mentally unable to stand trial. There's mental health issues. She does have a telephone where she can keep in contact with the public defender's office. And I believe the state has no objection.
State has no objection to an ROR, Your Honor.
Okay, with the agreement of both the state and defense, this case will be ROR'd. Okay. Yes, both charges are ROR'd. Okay, next up is Davi Kane. Am I saying your name correctly?
Yes, sir.
Okay, Mr. Kane. You're charged with trespassing on property after a warning. I'm appointing the public defender to serve as your attorney. Did I see a note that there may be a plea in this case?
State did convey an offer to Mr. Kane of an adjudication of guilt, credit time served, and no return to the links at 455 North Garland.
Is the offer accepted?
Yes, Your Honor, it's a plea of no contest.
Okay, do you have the plea form?
Yes.
Great. Okay, sir. Will the state please state the terms again?
An adjudication of guilt, credit time served of 2 days, and no return to the links at 455 North Garland.
Okay, sir, you understand you're pleading no contest to the charge on the trespass on property after receiving a warning?
Yes, sir.
Okay. You understand that as part of your plea agreement, you'll be adjudicated guilty. You will no longer be allowed to return to this location. And what was the other condition?
Just adjudication, no return.
Yeah, and you'll be sentenced to the time you've already served. Do you understand that?
Correct, sir.
Okay. Do you wish to enter that plea?
Yes, sir.
Okay. Did you read the plea form?
Yes.
Do you understand it?
Yes, sir.
Would you have any more questions for your attorney about the plea form?
No, sir.
Do you have any other questions for your attorney?
No, sir.
Okay, I'm going to accept the plea. He's adjudicated guilty, no return to the scene, and he's sentenced to time served. I'm sorry? Court costs will be reduced to judgment.
So you'll go home today.
Thank you.
All right, sir. Have a nice day.
Scott Kennedy, bonded.
Okay. Okay. Next up then, I have Carlos Martinez. Are you Mr. Martinez? Yes, sir. Good morning, Mr. Martinez. Mr. Martinez, you've been charged with 2 counts, loitering or prowling and possession of cannabis less than 20 grams. I'm going to appoint the public defender to represent you in this matter.
State did convey an offer to Mr. Martinez on count 1 of an adjudication of guilt, credit time served, no return. And in exchange for a plea to count 1, state will no info the cannabis count 2.
Okay, is there an agreement on this?
Yes, Your Honor. Mr. Martinez would like to accept and enter a plea of no contest.
Okay. So he's going to be pleading to the loitering charge?
Yes, Your Honor.
Okay. So, sir, you understand you're going to be Pleading no contest to the loitering or prowling charge, you're going to be adjudicated, in exchange, you're going to be adjudicated guilty on that charge. The possession of cannabis charge is going to be dropped, and you're going to have, not be able to return to the scene, and you'll be sentenced to the time you've already served. And you'll be subject to court costs. Do you understand that? Do you wish to enter that plea?
Yes.
Have you had a chance to discuss it with your attorney as much as you would like?
Yes.
Did you read the plea form?
Yes.
Did you understand it? I need verbal responses.
Yes.
Do you wish to enter into this plea form?
Yes.
All right. The plea is accepted. He is adjudicated guilty on the loitering or prowling charge.
And,
Credit time served. No return to the scene.
Your Honor, there's two, looks like it says Home Suites and Staybridge. The state's asking for both.
I'm sorry, say that again.
Your Honor, there was two addresses listed. It was a Home Suites and Staybridge Suites. I just wanted to make sure my client knows he can't go back to either location.
Both locations, sir. Both locations. Court costs will be reduced to judgment.
Thank you, Your Honor.
And state has an announcement as to count 2, the possession of cannabis under 20. State announces a no info, and I'm following that up right now.
Great.
That's it.
All right, next up, I have Jacob Ramos.
Yes, sir.
Mr. Ramos, you're charged with providing a false identification to a law enforcement officer. I'm going to appoint the public defender to represent you for today.
And there's not an offer at this time, Your Honor.
I do find probable cause in this case. I'm inclined to set a bond of $500. Anything from the state?
No, Your Honor.
Anything from defense?
No, Your Honor.
All right, sir, I'm setting a bond in your case of $500. Do you have any questions for your attorney before you go?
No, sir.
Okay, sir, you have a nice day.
Your Honor, Joe Wilson, his behavior.
Okay? Joe Wilson will be reset.
Ms. Anderson is bonded.
Okay? All right, let's slow down. Take your time, Madam Clerk. Take all the time you need.
May I approach, Madam
Of
Clerk?
course. You need some paper clips? I've got a ton. Yeah, no, I don't use them after I take them off. They're all yours.
Leave them on, that'll be perfect. Ramos. And who you said Wilson was what behavior?
Yes. Yeah, he's being reset.
So recent. Somebody 24.
And then I heard the next one, Anderson bonded.
Yes, sir.
Okay.
And
Okay, I'm ready.
Johnny Anderson bonded.
Okay. I'm ready.
Are you all set?
I'm all set.
Okay. Okay, Naeem Kane bonded. Okay. Okay, Jason Granich bonded. Okay. The next one I have, I don't have a Jose Fernandez next. I have Darian Thomas. Oh, I'm sorry. The stacks were stuck together. Yes. Jose Hernandez bonded.
Yes.
Okay. Next up, Darian Thomas. Are you Mr. Thomas? Good morning, Mr. Thomas. So you've been charged with 2 counts of a failure to appear. I'm going to appoint the public defender to represent you in this case.
Your Honor, state conveyed an offer to Mr. Thomas on both his expired registration and his Dwillis of an adjudication credit time served on both.
Okay. Is the offer being accepted?
Yes, Your Honor.
Okay.
And he would like to enter a plea of no contest.
Okay.
Let's see how much time we got. Give me a minute, you guys. I wish you would. I got to look it up. Give me 1 second. I got to see how much time we got.
He has
Okay.
2
All right,
days.
take your time.
He has 2 days.
For the FTAs? Prior to that,
None. He was never arrested on it until yesterday.
oh, he got 2 days on each one? Okay, all right, we good then. You serious? Just have to write it out later, 6131. Yeah, okay.
All right, so the charge he's pleading no contest to is both the expired registration charge and the failures to appear?
No, just the underlying, Your Honor.
Just the underlying, are the failures
registration
to
and
appear
the
being
tort.
dropped?
They were never formally charged, Your Honor, so he's just pleading to the underlying offenses.
Okay, but, hold on.
So we usually plea them, Your Honor, and then they get released. I don't know, I don't know if we need to do anything else. Because usually they get released once they resolve the case.
We got 2 cases resolving.
Yeah, so I've got the original charge, I've got 2 counts of failure to appear. So unless those counts are not, or unless those counts are no information, I need to
No, it's
deal with
not
the failures to appear, don't I?
That's not
That's a
what he's
separate
saying.
crime.
Well, the failures to appear were never formally charged, so whenever he pleads to the underlying, he's released to the failures to appear as there's no case to hold him on any longer. So he usually just pleads to the 2 underlying, and that's all that occurs out here.
Okay, all right. I mean, failure to appear is a separate crime. Even if
Yes.
your original charge goes away, you can still be charged with failure to appear.
And he hasn't been, and he's not going to be if he pleads to the underlying offenses.
Okay.
Okay. So what you're saying is you're no processing the failures to appear.
So we don't even have it in our system because we don't even treat them as like a new offense.
Rebecca,
Okay, all right.
do you guys have any? Okay, yeah. So, yeah, they said the judge will release him. I don't know why, Your Honor, but when they usually plea here at IAs, the failures to appear go away, once they plead to the underlying offense.
Okay, all right. Well, sir, do you understand you're going to be pleading no contest to the crime of driving with an expired registration?
Yes.
And it's expired more than 6 months? Do you understand you'll be adjudicated guilty and sentenced to the time you've already served?
Yes.
Okay, and as well as court costs?
Yes.
Okay, do you wish to enter that plea?
Yes.
Yes.
Have you had a chance to discuss it with your attorney as much as you'd like?
Yes.
Did you read this plea form?
Yes.
Did you understand it? Did you sign it? I'm sorry?
You did,
Oh,
you
yes,
just signed,
yes,
that's the form you
Is that
signed.
your signature, sir?
I'm
He's in pain from an auto accident, that's why.
Okay, that's all right. You can take your time, but I do need answers from you. Did you sign this form?
yes.
Okay, do you wish to enter into it?
Yes.
Okay, all right. I'm going to accept the plea. He'll be sentenced on the driving with an expired registration charge to time served, adjudicated guilty. And I don't know how the paperwork works, but to the extent we need anything on the failures to appear, he's ROR'd. Or if they go away, that's fine, but to the extent we need something in the file, he's ROR'd on those.
Well, Constable, you give him a year to pay.
The court costs will be reduced to judgment.
Okay, I'm gonna have to pass out the order. Right away.
All right, that's fine. Okay. All right. All right,
That was-
Darius Walker. Are you Mr. Walker?
Yes, sir.
Good morning, Mr. Walker.
Good morning.
Sir, you've been charging with driving with a suspended or revoked license. I'm going to appoint the state attorney to represent you in this matter.
The public defender, Your
I'm sorry, yeah, no, that would not work. I'm going to appoint the public defender to serve as your attorney in this matter. I do find probable cause. I'm inclined to set a bond of $500. I'm not inclined to revoke the previous bond. Anything from the state?
State did convey an offer to Mr. Walker of an
Okay.
adjudication credit time served,
And Mr. Walker would like to accept and enter plea of no contest.
Okay, great.
and if he is playing state, would request no action on his out on bond, as Your Honor otherwise said.
Yeah, they're not taking any action on that, okay?
So the offer only pertains to the driving with a suspended license?
Yes, Your Honor.
Yes, Your Honor, and on the, I think I have the wrong case number listed on my sheet, Your Honor, that's why I didn't put the case on the top of the plea form.
Okay, I can write it in. I have the case number as 2022 CT 4093AL. Is that the right number? Okay, I'm going to write it in.
Thank you, Your Honor.
2022 CT 4093AO. All right, sir, do you understand that you're going to be pleading no contest to the charge of driving with a suspended license?
Yes, sir.
Do you understand that you're going to be adjudicated guilty and sentenced to the time you've already served?
Yes, sir.
Okay? As well as court costs?
Yes, sir.
Okay. Do you wish to enter that plea?
Yes, sir.
Okay, did you have a chance to discuss it with your attorney as much as you would like?
Yes, sir.
Okay. Did you receive this plea form?
Yes, sir.
Did you read it and understand it?
Yes, sir.
Did you have a chance to discuss it with your attorney as much as you'd like?
Yes, sir.
Do you wish to enter into it?
Yes, sir.
Have you signed it?
Yes, sir.
All right, I'm going to accept the plea. On the underlying charge of, on the charge of driving with a suspended license, he'll be sentenced to time served, adjudicated guilty, court costs reduced to a judgment. I'm going to no action. I'm not revoking the prior bond on the stalking case.
Thank you, Your Honor.
Good day, sir.
Your Honor, Mr. Wilson bonded.
All right, Mr. Wilson bonded. You need me to slow down?
Alexander?
All right, do I have Algie Alexander?
Yes, sir.
Good morning, Mr. Alexander. Mr. Alexander, you've been charged with grand theft in the third degree of a motor vehicle, introducing contraband into a state facility, trafficking in methamphetamines of an amount greater than 10 grams, less than 200, and driving while your license was revoked. Did I state those correctly?
Yes, Your Honor.
On the grand theft charge, I'm inclined to set a bond, I do find probable cause. On the grand theft charge, I'm inclined to set a bond of $1,000. On the introducing contraband to a state facility, $1,000. On the methamphetamine tracking, $25,000. And I'm gonna revoke the prior bonds for the possession of cocaine with intent to sell and the driving without a license. Anything from the state?
Your Honor, there's that one additional count of the HTO Dwellis.
He picked up a new driving while license. This one.
Understood. Bond on that will be $1,000.
Nothing further, Your Honor.
The trafficking is 25,000. Each of the other charges are 1,000. And I'm revoking the two prior bonds in case numbers 2022 CF 8503. That bond is revoked. And 2022 CF 8503. It looks like that's the same case for two charges. That bond is okay. I think the prior case number was 2022 CF 4332. Is that correct? And 2022 CF 7048. Those are the two prior cases.
Yes.
Yes, sure.
Bonds in both those cases are revoked.
And then his new Willis, you reduce that to 1,000, 2,500. He should have two places.
It's 25,000 on the trafficking, 1,000 on each of the other current charges. I'm revoking the two prior bonds.
Did he have another driver's license suspended?
1,000.
It's 1,000.
That's 1,000.
It's 1,000. Okay.
And Madam Clerk, I'm sorry, on Walker, who took a plea for the driving while license suspended, does he need fingerprints?
Yes.
Yeah,
Okay.
and so do Thomas. Thomas need print too, I'm sorry, y'all.
Okay, tell me if you need me to slow down or anything.
Right behind you, back.
All right, next up.
Ms. Alexander bonded, Your Honor.
All right, Makita Alexander has bonded.
She refused?
Oh, she refused? Okay, Makita Alexander will be reset for tomorrow.
She bonded. She bonded.
Okay, we're clear she bonded?
Yes.
She bonded.
All right, Makita Alexander bonded. All right, Osmani Barreto Jimenez.
He bonded.
Really? Okay, that's a big bond. Okay,
I have Mr. Bassett next.
Mr. Bassett. Good morning, Mr. Bassett. I'm going to appoint the public defender to serve as your attorney today. So I find probable cause on the robbery. I'm not sure about probable cause on the burglary. The burglary charge was he was already in the building, had a right to be in the building, had not been asked to leave, and went behind the counter without permission. I don't think that counts as entering a dwelling. I don't think there's probable cause on the burglary charge.
Your Honor, state also agreed that there was no PC, however, for different reasons. But state agrees that there's no PC on the burglary. State would just ask that you set a bond on count 2, the attempted robbery.
Okay. As to the robbery charge, I'm inclined to set a bond of $10,000. Anything from the state?
Your Honor, state would ask for no return and no contact with the victim.
Anything from defense?
No, Your Honor.
Okay. Sir, on the burglary of a structure, it's going to be ROR. On the attempted robbery, your bond is set at $10,000. You're not permitted to return to this scene, to this store, and you're not permitted to have any contact with the woman who was there. Do you understand the conditions of your release? If you violate the conditions of your release, your bond may be revoked and you'll be in jail pending your trial. Do you understand? Do you have any questions for your attorney before you go?
Okay.
Okay. Next up, I have Kajavian Bolden. Okay. Sir, you're charged with open carrying of a weapon or firearm and 2 counts of destruction of evidence. I'm going to appoint the public defender to serve as your attorney. I do find probable cause. I'm inclined to set the bonds at $1,000 on each of the destruction of evidence charges, $100 on the open carrying. Anything from the state?
No, Your Honor, just no weapons or firearms.
Yeah, no possession of weapons or firearms. Anything from defense?
No, Your Honor.
All right, sir, for the destruction of evidence charges, your bond is going to be $1,000 for each charge for a total of $2,000. The bond for the open carrying is going to be $100, and you are not to possess any firearms or weapons. Do you understand? Okay. If you violate the conditions of your release, your bond may be revoked, and you'll be back in jail pending your trial. Do you understand the conditions of your release? Do you have any questions for your attorney before you go? Can I get a verbal response? Okay. Have a nice day, sir.
Your Honor, Mr. Broom bonded, Julian Broom.
All right, Julian Broom bonded.
Next, I have Eric Cruz.
All right, Eric, are you Eric Cruz? Good morning, Mr. Cruz. All right, Mr. Cruz, you're charged with battery on a uniformed licensed security officer. I'm going to appoint the public defender to serve as your attorney. I do find probable cause. I'm inclined to set the bond at $2,500. Anything from the state?
Your Honor, state would ask for no return, no contact.
Granted. Anything from defense?
No, Your Honor.
All right, sir, your bond's going to be set at $2,500. You're not to return to this store at all, and you're not to have any contact with the officer. Do you have any questions about the conditions of your release? Okay, do you have any questions for your attorney before you go?
Can I get your phone number?
It's right here. That's what I was gonna tell you.
All right, next, Douglas Hightower. I do find probable cause on all charges.
Your Honor, I believe it's a capias.
It is.
So say
I
we
have the
asked for-
capias for the cocaine. Hold on, let me look at the paperwork here.
Yeah, I was a little confused at first too.
Yeah, I see that.
It should have just came, it should have said KPS instead.
Fine, you're fine. All right, on the cocaine, the bond's gonna be 5,000. Did I point, sir, I'm gonna appoint the public defender to serve as your attorney?
Your Honor, are
We
you
have
talking about
cocaine, Your
Douglas Hightower?
It's just the burglary.
It should be a burglary
And petty
structure
theft.
and petty theft.
So I have burglary, petty theft, and also a cocaine charge. I have two. I have one affidavit with burglary and petty theft. I have a second affidavit for sale delivery of cocaine.
Is that him?
No, that's not him.
Ah, okay, they put the two packets together, I'm sorry. Okay. No, the paperwork was out of place. Okay. On the burglary charge, it's gonna be $2,500. On the petty theft charge, it's gonna be $250. Anything from the state?
Your Honor, it's a KPS. They would ask that it remain at none, as Judge Wilson in Division 15 set it at none, and it's a KPS, so he's not entitled to one at this time.
I believe she said that's up to the first appearance judge, did she not, when I looked at it?
Your Honor, they would just point to the 50 CA Norris, just saying that I don't have the warrant in front of me, however, it came in at none. I don't know if on there it says it can be changed, however, since it came in at none, it would ask that we state at that, given that it is a KPS on violent offenses.
I think it's based off of the warrant. Let me just double check. I don't know why it's not pulling up.
Your Honor, it says revoke release. These bonds are not to be modified by the initial appearance judge, setting it at none by Judge Wilson in Division 15.
I stand corrected. I stand corrected. Okay. Anything from defense?
No, Your Honor.
All right, it's gonna be no bond. Sorry, the paperwork for two of them were mixed together.
Mr. Johnson bonded, Your Honor.
All right. Lovis Johnson bonded. Next, I have Terrence King. Good morning. Are you Mr. King? Good morning, Mr. King. Mr. King, you're charged with possession of cocaine, possession of methamphetamine, possession of cannabis less than 20 grams, introducing contraband into a county detention facility, and possession of cocaine. I understand he's also out on bond and driving with a suspended registration. You see here, and driving without a valid license and petty theft of $100 or more. Did I get those right?
Yes, Your Honor.
Yes.
He is a private attorney in those cases.
Oh, there's a private attorney here?
No, on the out on bonds, he already has a private, so I just ask that you appoint us only to the new law.
Yeah, the public defender is appointed on the new charges. What's the position of the state?
Your Honor, state would just ask for reasonable bonds on all his new offenses, and given that his out on bond offenses are not of the same nature, state would ask for no action at this time.
All right, on the possession of cocaine charge, bond is gonna be $1,000. On possession of methamphetamine, it's gonna be $1,000. Possession of cannabis, $250. No action on the prior bonds.
Your Honor, he also has the introducing and the other cocaine.
What was the second one?
He has the introduction of contraband and the other cocaine case and the 8518 case.
It's gonna be $1,000 on each of those. Next, I have Jamson Levins.
His behavior, Your Honor.
Okay, he'll be reset for tomorrow. Jamson Levins is reset. Next, I have Eric McCray. Sir, you're charged with a failure to appear. I'm going to appoint the public defender to serve as your attorney today. I'm inclined to no bond this. Anything from the state?
Your Honor, it came at $2,500, the state will leave that within your discretion.
It's a failure to, it's a failure to appear in a battery case. I'm inclined to no bond it. Anything from defense?
No. Your Honor, if the judge on the case set a bond, I would ask that you just stay the bond that was set on the capias. Oh,
I mean, I see the bond set on the battery charge, and I see the recommendation on the affidavit. I don't see a judge has set the bond as to the failure to appear charge. Am I wrong?
let me just,
Yes, Your Honor, it came in at the
I'm sorry?
2,500, I believe. I'm double checking, but I believe Judge Wooten,
Okay. I have the
20.
I have the bond set at 2,500 on the battery charge, and I see the recommendation from, on the warrant, on the arrest affidavit as to the failure to appear. I don't see a bond on the failure to appear having been set by a judge yet. Please tell me if I'm wrong.
what I see, Your Honor, is that the judge did set a bond, defendant for failure to appear for pretrial conference on 6/17. And then it says the court has ordered bail to be set at 2,500. And it was signed, oh, maybe it's Tiffany. I don't know.
I don't have that paperwork. State, do you agree that the judge wouldn't set the bond?
Yes, Your Honor, on the KPS itself, yeah.
All right, it's gonna be a $2,500 bond, sir, on the failure to appear. Yeah, $2,500 bond. Do you have any questions for your attorney before you go? Okay, have a nice day, sir. Okay, next up is Armando Rentas. You, Mr. Rentas? Good morning, Mr. Rentas. So you're charged with a failure to appear for possession of cocaine charge. I'm going to appoint the public defender to serve as your attorney. What's the position of the state?
State would ask that you stay at 2,000.
Defense?
I agree, Your Honor.
All right, so your bond is going to be $2,000. Do you have any questions for your attorney before you go?
No, is that gonna be 2,000 or just the 200?
Do you have any you can ask any questions you like of your attorney, sir. If your attorney would like you to speak to me, you can, but just make sure you talk to your attorney first.
Welcome.
Your Honor, Ms. Reyes is mental health.
All right, Ms. Reyes will be reset. Kevin Richardson?
Yes, sir.
All right. Okay, Mr. Richardson, you're charged with possession of cannabis greater than 20 grams, possession of burglary tools, and loitering or prowling. There's a bond on a prior charge for aggravated assault with a deadly weapon. I'm going to appoint the public defender to serve as your attorney today. I'm inclined to set a bond on the cannabis charge of $1,000, on the possession of burglary tools at $1,000, and the loitering or prowling charge $100. I'm inclined to revoke the prior bond. Anything from the state?
No, Your Honor, state would just ask for a no return to 8132 St. Andrews Circle.
Okay. Anything from defense? Take your time.
Your Honor, just for your knowledge, the out on bond is actually 2 counts of ag assault with a deadly weapon.
Okay. They're both revoked.
because you picked up a new law. No, Your Honor.
All right, so the bonds are gonna be, as I stated, 1,000 on possession of cannabis, 1,000 on burglary tools, 100 on loitering or prowling. No return to, will the state state the address again?
No return to 8132 St. Andrews Circle.
And the bonds in the prior case for the two charges of aggravated assault with a deadly weapon are revoked. Sir, do you have any questions for your attorney before you go?
Yes, Your Honor.
Okay, I have Levante Ricks.
Yes, sir.
Are you Mr. Ricks?
Yes, sir.
Good morning, Mr. Ricks.
One.
All right, you're charged with possession of oxycodone, sir. I'm gonna appoint the public defender to serve as your attorney. And I'm told there's a hold from Pinellas County, am I right?
Yes, sure.
Correct.
Okay. All right, I'm inclined to set a bond of $1,000 in the Orange County case here on the possession of oxycodone, and he'll still be transferred to Pinellas County. Anything from either side?
No, Your Honor.
Yeah.
All right, sir, I'm gonna set a bond on your case here, but Pinellas County has asked Orange County to hold you, so you will be transferred to Pinellas County, okay? Do you have any questions for your attorney before you go?
Yes.
Take your time.
Does he have a bond on the Pinellas County cases?
I'm sorry?
Oh, I was speaking of pretrial services, Your Honor. If he had a bond on the, hold. Pinellas County. Oh, yeah, you can back out from here.
Thank you, Your Honor.
Have a nice day, sir. All right, next up is James Rivera. Sir, you're charged with one count of possession of cocaine. I'm gonna appoint the public defender to serve as your attorney, okay? All right, I do find probable cause. I'm inclined to set the bond at $2,500. Anything from the state?
No, Your Honor.
Anything from defense?
No, Your Honor. Any questions?
All right.
Here. Okay. You can bond out.
No, I said Rivera was 2,500.
Oh, it's staying, I'm sorry.
Are you Mr. Robinson?
Yes, sir.
All right, good morning, Mr. Robinson.
Good morning.
Sir, you're charged with burglary to a non-occupied structure and criminal mischief greater than $1,000. I'm going to appoint the public defender to serve as your attorney. This was a warrant.
Your Honor, it looks like he qualifies for pretrial release. I don't see any convictions on his record, so I would ask for pretrial release.
What's the position of the state?
Your Honor, state has no objection to PTR. State would just ask for no return to the sit-go
All right, sir.
gas station.
I'm gonna grant you PTR. That means there's gonna be conditions on your release, one of which is no return to the Citgo station. Do you understand?
Yes, Your Honor.
Okay, do you have any questions for your attorney before you go?
No, sir. Thank you.
All right, good luck to you, sir. Next up is Reginald Siegler.
Yes, sir.
All right, sir, you're charged with second-degree murder with a firearm. I'm going to appoint the public defender to represent you today. This is life. This is a potential life felony, correct?
Yes, Your Honor. Given that it is a first-degree felony that is punishable by life, state's requesting that you hold him no bond pending an Arthur hearing downtown.
Defense?
No objection. We reserve our right to have Arthur hearing, Your Honor.
Okay. Sir, I'm going to hold you at no bond at this time. You will have a right to request a bond hearing before the judge assigns you your case, okay?
Yes, sir.
Your Honor, state would ask for no contact with the victim's family or any witnesses.
Well, I'm no bonding him, so I don't, can I put, I don't think I can put conditions when I've no bonded him.
You can, Your Honor, when he's in jail, because he still has the ability to contact anyone from the jail phone. So you can put conditions.
Defense?
Usually there's not conditions like no weapons or firearms. They'll set that later when they do the Arthur hearing.
I have no objection to the no contact, Your Honor.
All right. No bond, no contact. Next up is Charles Swearinger. Sir, you're charged with 2 counts of sexual battery on a child between the ages of 12 and 18. I'm going to appoint the public defender to serve as your attorney. I do find probable cause.
Your Honor, these are, 2 counts are capital, so state would again be requesting no contact and a no bond.
Defense?
Your Honor, I would ask that, given that you have the discretion to set a
I'm
bond.
not setting a bond.
Oh, okay. Then I have no questions, Your Honor. I have nothing to say. He has no questions.
Sir, I'm not setting a bond for you today. You will have the right to request a bond hearing with the judge assigned to your criminal case, okay?
Okay.
Do you have any questions for your attorney before you go?
Can I have one?
Take your time.
Right.
Your Honor,
Thank you, Your Honor.
state would request no contact with the victim, the witness, or any child under the age of 18.
Granted. Sir, do you understand the conditions? Don't contact anyone from the jail, not the victim, not the child. No, and you're not allowed to contact anyone under the age of 18 from the jail, okay? All right. All right, next up, Paul Taylor.
Yes, sir.
Sir, you're charged with trafficking in methamphetamine between 10 and 200 grams. I'm going to appoint the public defender to serve as your attorney in this matter. I do find probable cause. What's the state's position as to this bond?
Your Honor, that is what the bond schedule comes in for the trafficking. In addition to the amount of money that he had on him, he also has other failures to appear, VOP, and other drug offenses. They would ask that you stay it at this time. State's concern is the failure to appear in the VOP. They've shown an inability to comply with court orders. And he has other violent offenses and other drug offenses. And given that that's what the bond schedule comes in at, state would ask that you stay that at this time, understanding that Mr. Taylor can file a bond motion to get it reduced.
Defense? Take your time.
Your Honor, I would ask that you reduce the bond amount, in this case to $10,000. My client can't afford the $50,000 bond.
What concerns me is the failures to appear, counsel.
Yes, Your Honor.
Please address that.
Yes, his family resides here, all of his family. He has,
Was that true when he committed the last failures to appear?
oh, Your Honor, for the last two failures to appear that he had, the issue was that he was actually transient at the time. So the address that they had on file, they actually sent his court hearings to the wrong address. He currently has a permanent residence at this time where he receives all of his mail. He is currently up to date with his registration where he would get all of his court dates into, Your Honor. So I just ask that you consider that factor and the factor that he's resided here all his life, and his family also resides here.
I'm gonna keep the bond at 50,000. Sir, do you have any questions for your attorney before you go? All right, next up, believe those are our last ones. Shamal Taylor. Shamel?
Yes, sir.
You, Miss Taylor?
Yes, sir.
Good morning, Miss Taylor.
Good morning.
Ms. Taylor, you're charged with 5 counts of failure to appear. I'm going to appoint the public defender to serve as your attorney.
I'm sorry.
You're charged with 5 counts of failure to appear, and I'm going to appoint the public defender to serve as your attorney. Do you understand?
Yes, sir. Can I ask one question?
You have a right to speak if you'd like, but I would strongly urge you to speak with your attorney first and to follow whatever advice she gives you as to whether or not to speak.
To appear, right?
This is 5 different. Hold on, just give me a second, let me show you. Yes. It's not. It's the same case. Thank you, Your Honor, she understands now.
I'm inclined to no bond this. It's failures to appear on serious crimes.
Your Honor, I would ask that you stay at no bond.
Defense?
Yes, Your Honor, I believe that's correct. No,
All right, it's going to be no bond on the 5 failures to appear. Ma'am, if you have any questions for your attorney, feel free to ask them before you go, okay?
There's the 133, yeah.
Sorry?
it wasn't. That's what I'm telling you. You're gonna have to.
Okay. We have 133 day that we kept for the second session, or is the state prepared to proceed on that?
Yes, Your Honor.
Okay. 22 CF 6537, John Walter Cobble.
Granted, notice of non-filing.
That'll be granted. I think that concludes our business for today, folks.
Thank you, Your Honor.
I believe
Have a wonderful day.